Good morning, everyone. My name is Amy Hemenway. I have my colleague Lindsey with us this morning. Thanks for joining this month's Your Morning Briefing. After a rather quiet year in 2025, we started to see a lot of activity at the federal and state level, and we want to share that with you. We want to provide some updates and give you some things to think about as you start working your way through 2026.
Before we begin, we have some housekeeping items to share. First, our presentation is for informational purposes only. We'll talk through important updates that you should be thinking about, but our presentation is not legal advice. If you have a specific legal question, you can feel free to reach out to Amy or to myself after the presentation, and we'll be happy to walk you through it and discuss it in more detail. Second, we are offering CLE and HCRI and SHRM credits for today's presentation. We'll provide the codes that you'll need to submit and information on how to do that towards the end of the presentation, so stay tuned.
All right, so before we dive into the updates, I want us to step back and think about the last year. We had an administration change at the federal level, and usually when that happens, we see a lot of quick flurry of activity. The agencies are pumping out new regulations, they're changing positions on a number of different fronts, and that can be really challenging for employers who are trying to play catch up and stay on top of things and, implementing a lot of new policies often and things like that. And oftentimes when you have that flurry of activity with an administration change at the federal level, you'll start to see things at the state level where they're trying to balance or counteract depending on who's in office. And it really is quite a busy time. But last year, when the Trump administration took over, they immediately went into the DOGE situation and really were looking at the government, making a lot of cuts. And that led to sort of an icing of the agencies in a way where they weren't able to do anything because they kind of weren't sure what the lay of the land was. And then once that process was sort of coming to an end, we entered the budget shutdown period, which meant that the agencies weren't even open. They weren't operating in many respects. And that, of course, meant that regulations weren't coming out. We weren't seeing policy changes or things like that. And then we had a lack of appointments on top of that, which led to not having quorums or the right number of people in the right positions to be able to take action at the different agencies. So we had a much slower start than we expected to in 2025. We're finally starting to see movement in the last 2 weeks. There were a number of things that came out at the federal level, and we'll walk you through all of those different things.
And thanks, Amy. So you mentioned a flurry of activity, and that applies both at the federal and the state level. So let's start at the federal level. One thing that I've been hearing about is the NLRB's joint employer rule. Can you fill us in on what's going on with that?
Sure. So right at the end of February, the NLRB published a final rule for determining joint employer status under the National Labor Relations Act. And the rule should be familiar to employers because rather than crafting a new rule, the board reinstated the same rule that had put into effect in 2020 under the first Trump administration. So the rule that's now in effect, and they just put it into effect without proposed rulemaking, that rule outlines 2 conditions that must be met for 2 employers to qualify as a joint employer. First, the 2 employers need to co-determine the essential terms and conditions of employment. And then second, the putative joint employer needs to possess and exercise some kind of substantial, direct, and immediate control over one or more of those essential terms and conditions of employment. So the control needs to be exercised in a way that meaningfully impacts the employment relationship. So we're looking for, not just something on paper, not something, that they could in theory do, but they're actually exercising the control in a way that has an effect on the employees that are covered by the joint employment relationship. And that analysis is based on a totality of the facts in a specific setting. So it may vary, based on your employees and things like that. The board has identified 8 essential terms and conditions of employment that should be considered. So when employers are looking at their relationships with vendors, maybe we're thinking about temporary employees that are present in the workplace, or you're working with a staffing agency, things like that for recruiting. These are the items that you're going to want to key in on and think about, are we handling this in a way that makes us a joint employer with this other entity? So that includes wages and benefits, hours of work, the ability to hire or discharge employees, who has the authority for that, who's deciding discipline and implementing the discipline, who's supervising the employees. Sometimes in a temporary worker situation, the employer that's hosting those temporary workers will provide the supervisors. In other cases, there are times where a temporary agency will actually send in a supervisor who's responsible for managing, the day-to-day aspects of the employment for those workers. Who's directing the work and deciding what needs to be done, when it needs to be done, how it needs to be done. And we're, again, looking for substantial control in one of these different areas.
So, Amy, when it comes to the reinstated rule, what should employers be thinking about?
Well, as I mentioned, the rule has these 8 essential terms and conditions that you're looking at to see whether there's some type of control. And they're pretty nuanced. So employers will want to be thoughtful about where they're retaining control and where they're willing to relinquish it when they enter into and administer these arrangements with contract workers, staffing agency, or other third-party labor partners. Another thing that they want to keep in mind is that this is one test used by one agency. So this is how the NLRB is going to look at the joint employment issue, but other federal and state agencies may have their own view and their own test for this type of an arrangement. And the fact that you are able to satisfy and say, confidently under the National Labor Relations Act, I don't think we're a joint employer, doesn't mean that you will satisfy another agency's test. So you just want to be mindful of that and look holistically across both the federal and state level and the different agencies to determine where your standards fall.
A lot to consider.
It is.
So I understand that there's also been changes happening at other federal agencies. Can you talk to us about what's been happening at the U.S. Department of Labor?
Yes. So right around the time that the NLRB pumped out its rule, the Department of Labor Wage and Hour Division issued a proposed rule related to how independent contractors are classified. So this proposed rule is very similar to a rule that was adopted in 2021 under the first Trump administration. Something to keep in mind, that original rule, this is slightly different, but the original rule was challenged in a number of different courts. One of those challenges is still pending, so that may bear on this current rule that's, again, proposed. If it's finalized, it will determine the analysis for independent contractors under the Fair Labor Standards Act, the FMLA, and the Migrant and Seasonal Agricultural Protection Act. So it calls for a return to what we refer to as the economic realities test, which is a test that looks at 2 core factors: the nature and degree of control over the work, who has that control, and then the worker's opportunity for profit or loss, right? Are they able to make a gain, or could they be subject to a loss based on their own initiative and investment into the relationship? Some secondary factors that may influence this analysis include things like what skills are required for the job. Are they something that, other workers would have, or is this a special skill that we're bringing in to help with a particular project or things like that? The permanence of the relationship. The longer it goes on, the more likely someone starts to look like an employee and not a contractor. And then how does that work relate to the business of the employer, right? If your company is providing accounting services and you contract with an accountant to do the same work that your employed accountants are doing, they're going to look more like an employee. If you are a manufacturer that is pumping out circuit boards and you contract with an accountant to come in and help do your books, they're not doing the work that your core group of employees is. So that may be more likely to be an independent contractor relationship if it's otherwise set up correctly. So consistent with what we've seen in the past, how this relationship operates in the real world is really what's going to influence and be instructive as to whether you're talking about an independent contractor or an employment relationship. We know that oftentimes employers will say, well, we have a contract that says they're an independent contractor. And that, can be helpful in shaping expectations, but that's really not what carries weight. It's how things are put in place and how the relationship operates in the real world.
Yeah, we see that often, right?
Yes.
Where with the contract. So I imagine that, like we see with the joint employer issue, different agencies may have different tests when it comes to determining who's an independent contractor.
Yes, I think we are going to see that. We know that's the case, particularly when you look at the federal agencies, which take a more hands-off approach, and then the state agencies, which seem to be more focused here in New York on finding a relationship that's consistent with employment rather than independent contractor status. So there definitely is some tension there. You need to think about that with respect to wage and hour issues, things like unemployment and workers' compensation, whether or not you need to collect payroll taxes. Those are the places where employers, seem to find the greatest liability because they're not making the payments that they need to make for unemployment, workers' comp, or taxes, and those liabilities can add up very quickly. So employers, when they're thinking about whether someone's an independent contractor or an employee, will really want to test all of the different relationships under the possible laws to ensure the greatest mitigation of risk, right? Let's not just pick the easiest test and say we satisfy that. You want to make sure you're minimizing your risk under all the different laws that might apply.
Yeah, that makes sense. And I think looking at the, like you said, the totality of the relationship rather than just what's on paper under
Right.
all of those tests. So we've covered the NLRB and the DOL. Can you tell us what's been going on at the EEOC recently?
Yeah, so the EEOC, like the other federal agencies, had a slow start in 2025. Beginning at the end of January, we started to learn more about their agenda. They spent a lot of last year focused on DEI, and that was through the DOJ kind of attacking, DEI programs. Um, I think we'll continue to see that type of activity in some respect. But what they've done now at the end of at the very beginning of 2026 is rescind the harassment guidance that they put in place back in 2024 that related to gender identity and sexual orientation. So things like preferred pronoun use, bathrooms that could be used based on preferred sex rather than sex at birth. So that guidance has been rescinded. The agency has also expressed a shift toward reverse discrimination claims, right? This is their new focus, an area that they are going to be exploring. So when we talk about reverse discrimination claims, what we expect to see are cases where they're looking for discrimination against classes that have historically been viewed as receiving more favorable treatment. And so, men, um, Caucasians, in what we're expecting is that they're going to be looking at corporate DEI policies and initiatives and examining whether implementation of those types of programs is disadvantaging people in a way that is consistent with reverse discrimination. We also, the EEOC has also expressed that it will begin examining whether there's a use of foreign workers that's preferential and therefore discriminatory based on national origin. So we've heard a lot about the visas and, hiring foreign workers and bringing jobs back to the US. So oftentimes, in order to apply for a visa, an individual needs to show that, they can't, or an employer needs to show they can't find the skills here in the US. And we expect to maybe see some more pushback there. That's an area the EEOC has signaled could be of interest to them. And all of this will surely create a tension for employers that are trying to balance compliance with state laws, for example, here in New York, that require more thought and proactivity around issues like gender identity and sexual orientation, where, the state agency has said not using someone's preferred pronoun could be indicative of discrimination. The EEOC now has stripped back that guidance. So there is a tension there. And employers will just need to be thoughtful about how they're handling these issues. And I think take a stance that is more focused on compliance as opposed to being in a proactive state and trying to kind of go above and beyond what the law might require. So we'll keep an eye on that and we'll keep everyone posted for sure. So Lindsey, I just talked a little bit about what we're seeing at the EEOC, and I think that ties into an update you were going to share about the New York State human rights law.
Yeah, so just like you said, Amy, I think we're starting to see the states start enacting certain things to try to respond to what's been happening at the federal level. And this is one example of it. So the New York State human rights law was amended back in December to expressly codify disparate impact liability, which means that employers can be liable if a facially neutral employment practice has a discriminatory impact, even if there isn't a discriminatory intent. So some of the hiring criteria and different ways in which employers are enacting certain practices and policies, if it's having a discriminatory effect, where we're seeing preferential treatment given to one group or over the other, or just hiring of more folks in one class, that could be viewed as discriminatory, even if there's no discriminatory intent on behalf of the employer. And so under this sort of theory, if a particular policy or practice appears to have a disparate impact, an employer can defend it by showing that they have a legally sufficient justification, which means that it needs to be job related and consistent with business necessity, and that there's no practice that has a less discriminatory effect on the workplace.
So does this represent a change in the law? Because you said it was added, right, to the human rights law.
Yes. And so, no, this is not a new concept at all. This is something that has been prohibited under both federal law for Title VII and has been recognized in New York State for a long time. I think what we're seeing here is that this change, it's really codifying the current understanding of the law in New York State to ensure that it's protected here in the same way that it's been enforced, even if there are changes at the federal level trying to pull some of that back.
Yes. So back in January, Lindsey, our colleagues Ben and Anna used the morning briefing to talk about the Trapped at Work Act. And I understand that, here we are a month later and there's already been some changes. Can you walk us through those?
Yes, I know. Things are moving fast, like you said, in the last couple of weeks. So Ben and Anna talked about the Trapped at Work Act, and if you were sitting in on that, your morning briefing or listen to that program, you probably recall that they were talking about the fact that we were sort of in a limbo period where the law had been signed back in December, but that there were chapter amendments forthcoming that were going to significantly, or were anticipated would significantly change our understanding of the law and what those requirements were. And so what we've seen happen in the last couple of weeks is that those chapter amendments were signed, and they created some significant changes along the lines of what Ben and Anna were discussing back in January. So the three important changes that we want you to be aware of is that the chapter amendment delayed the effective date of the act. And so when it would be enforced, it narrowed the scope of who is covered by the law, and it clarified expectations with the broad prohibitions against the type of repayment agreements that it was intended to prohibit. If we sort of rewind a little bit back to what Ben and Anna covered last month, when the law was signed in December by the governor, the text of the legislation indicated that the act was going to be effective immediately, which didn't give employers any time to prepare for that change in the law. With the amendment, the implementation has been delayed by a year to at least December 19th, 2026, although there does seem to be a little bit of confusion and discrepancy from some of the sources who seem to think that it might be 1 year from when the chapter amendment was signed. Our understanding and our reading of the text is that it would go into effect on December 19th. What still isn't clear and what wasn't addressed by the chapter amendment is whether the act will apply retroactively. So whether it will sort of invalidate or call into question current agreements that don't align with the new requirements under the law, or if it was only going to apply to agreements that are entered into on or after the effective date of the legislation. In terms of the sort of narrowing of the scope, the original text of the law applied to workers was the term that was used, which implied that it might apply to non-traditional work arrangements in addition to what you think of as the normal employer-employee relationship, like independent contractors, interns, and maybe certain volunteers. With the amendment, though, the act changed the language that was used to using employee instead of worker. So employers can focus on ensuring that the agreements that they have with their traditional workforce are compliant.
So aside from those amendments, Lindsey, it was my understanding the original act was very broad. It prohibited a really wide range of agreements that a lot of employers use that were pretty commonplace. How did the amendment adjust for that or take that into consideration?
Yeah, so the amendment clarified that certain types of repayment agreements are permitted if certain conditions are met. And so the two big categories of these kinds of agreements are non-educational incentives like sign-on bonuses and relocation assistance and other kinds of financial payments that an employer might be fronting money to the employee. And then the second category are for educational reimbursements for transferable credentials or transferable credits that the employee might be getting.
Okay, so two areas. Can you walk us through the conditions that need to be met for those types of arrangements, just so that the employers are up to speed here?
Yes. Yep. So for repayment agreements that deal with transferable credits or transferable credentials, the law or the act specifies that they need to be contained in a separate written contract with the employee. So you can't include it as just a provision in the general employment contract or employment agreement that you have with someone.
Maybe an offer letter wouldn't.
Yep, offer letter. Yeah, it needs to be its own separate contract that satisfies the requirements. The transferable credential also can't be a condition of employment. So it can't be something that they have to have in order for that position. So if somebody is pursuing additional training or learning so that they might be qualified for a different position or, can better, understand certain things to advance their career, that's fine, but it can't be something that's required for the employee's current position. The repayment amounts must be specified upfront and can exceed the actual costs that the employer incurs. So you can't be sort of charging a premium for the credits. And the repayment schedule has to be proportionate and prorated for the service period. And you can't accelerate those payments if the employment ends earlier than anticipated. And then the last big one that's just still kind of a little bit ambiguous in my opinion is that employers can't require repayment if the employee is terminated except for misconduct. And unhelpfully, they don't define what misconduct is. And so this is an area that I think we're going to see sort of worked out through the courts in litigation or through further guidance on what exactly they're envisioning by misconduct and what situations would fall into that category. The other thing that is not expressly addressed by the law, but that is whether a voluntary separation is covered, although it seems to be everyone's understanding that the intent behind these is if somebody is, incurring these educational expenses and then they choose to leave voluntarily, that then you would be able to enforce the repayment agreement in those situations. But that would be something that would be nice to see them just sort of confirm through future guidance.
Agreed.
So those educational arrangements, those are kind of the big bucket of one of the things that employers were really concerned about. So if you think about like if you have somebody who's going to get their nursing degree or other kinds of things, you can still have those kinds of arrangements. You just need to make sure that the agreement conforms to the requirements that are set forth in the law. I think one of the things that's sort of open with that is, things like, Amy, we're in the legal profession, the bar exam. Passing the bar is something that is required, for our profession. But oftentimes employers are, before somebody is even hired, giving them a stipend to help study for the bar and things like that. Would those be covered? I think, it's going to be, time will tell sort of how it's being enforced and whether or not those kinds of things would be included.
Yeah.
The second category of agreements are the things like sign-on bonuses, relocation agreements, and other non-educational incentives. And for those kinds of agreements, those are typically allowed, but repayment cannot be required if the employee is terminated for any reason other than misconduct, which again hasn't been defined, or if the employer misrepresented the job duties. So what they don't want to have happen is if somebody, receive a sign-on bonus and then the employer go through a downsizing immediately afterwards and then turn around and say, okay, well, now you owe us the $10,000 signing bonus back. Or if somebody agrees to take on a job and the employer has really misled them about what the job duties would be, employers can't sort of be bad actors in that situation and require repayment of those kind of bonuses.
So when we think about this Trapped at Work Act and these new amendments, what should the employers be doing to prepare for it?
Great question. So, now that we have a little bit more time before it goes into effect, I would encourage employers to review any existing agreements that they have where that would require repayment by the employee if they were to leave, and determine which ones might be problematic under this new framework. Because it's not clear whether these are going to apply retroactively or if it's only going to be on a go-forward basis, cautious employers may want to consider entering into new agreements that would conform to these new requirements to ensure that they would be enforceable. And because, there are still some ambiguities, what does misconduct mean? The sort of voluntary resignation situation, things like that. We expect that there probably will be some litigation over the enforcement of these kinds of agreements going forward. And, if employers are wary of that or want to avoid, those types of disputes, they may want to avoid paying out large sums of money up front to employees and instead consider paying it out over a period of time so that there's less sort of at stake if repayment agreement is deemed unenforceable.
So I understand there are some other changes, including one that relates to background checks. Can you fill us in on those? Because a lot of employers do use background checks.
Yeah. So I know we're approaching the end, so we'll go through this quickly. But beginning on April 18th, employers will be prohibited from requesting, obtaining, or using credit history in employment decisions. And this includes things like credit reports, credit scores, or other credit-related information. In my experience, I think less employers use credit reports in employment decisions to begin with. But if this is something that you are using in your business and as part of your hiring practice, you'll want to pay close attention and make sure that you understand sort of the nuance here. There are several exceptions that were built into this prohibition on using credit-related information. I don't have time to go through all of them here today, but a couple that are noteworthy is if a credit check is required by law or regulation, employers are still allowed to run those credit checks. That's the one that we would expect to see for sure. There's also some exceptions in place for certain positions that require security clearance by law or certain law enforcement positions, and others that involve background checks by state agencies for public type positions. The ones that private employers are going to be most interested in paying attention to are the ones that apply to non-clerical roles with regular access to trade secrets, intelligence, or national security information. This is one that I think I would really caution you from sort of reading this broadly. I think the exceptions are intended to be read very, very narrowly. And the law actually made it clear that regular access to trade secrets is not something that includes like client lists or employer policies and handbooks. So they're already trying to sort of narrow the scope of what would be included in that. But again, that's something that may apply to your business. There are other exceptions for roles that have signatory authority over third-party funds over $10,000. So if you have an employee that's handling client funds, that might be something that you're still allowed to do a credit check for, and roles with a fiduciary duty to the employer or authority to enter into transactions over $10,000 on the employer's behalf for similar reasons. And then the last one is for positions with the ability to modify digital security systems. So people who really have the capacity to mess things up in a big way, there's an exception that could apply to some of those roles as well.
So when we, again, what should employers do to prepare for this if they're using those checks?
So I would review your existing background check practices within the next month and see sort of if you are using credit checks, what circumstances you're using them for, and make sure that the times that you're using a credit check do fit into one of the noted exceptions under the law. And if not, you might want to sort of shift gears a little bit to make sure that you're not running afoul of that new requirement.
Okay, so we have one final update that I think we wanted to share today that relates to what they call first aid supplies. Can you fill us in on that?
Yes. So beginning in December 12th of 2026, all employers will have to have opioid antagonists like Narcan available if they are required by OSHA to have first aid supplies available, which I believe it applies virtually to all employers. So the opioid antagonist has to be available, but it doesn't necessarily have to be included in the actual first aid kit that's accessible to all employees 24/7. But we expect that there's going to be regulations forthcoming that might sort of dig into a little bit more with what they mean by available and what those requirements really will impose on employers.
All right, so that brings us to the end of our presentation. If anyone has any questions, you can add them to the Q&A. We don't see any right now, but we'll keep an eye on that for the next couple minutes. But I'm going to have Lindsay go ahead and give our HRCI CLE insurance code credits.
Yeah.
Yes, codes.
So for for HRCI, the code is 736668. I'll read that again. 736668. The code for SHRM is 26-KJGWM. That's 26-KJGWM. And for CLE, the code is SPRING, SPRING, SPRING.
All right, so we've come to the top of the hour here. Our 30 minutes are up. I don't see any questions here in the Q&A. Oh, we do have one. So are there any changes to required notices or disclosures with regard to the background checks relating to the credit check change? So Lindsay, I'm going to defer to you on that one.
So the law didn't change any of the notice requirements there. However, I would encourage employers, if you're not doing credit checks, you may want to take a look at your disclosures and your authorization to see whether you're saying that you're going to run credit checks, because that could be something that in particular plaintiffs' attorneys might be looking for and vetting. So it's, while not required, it is something that I would encourage.
Okay, good answer. Thank you. So I don't see any other questions here. I want to thank everyone for attending today and hearing our updates. If you have any questions, again, feel free to reach out to Lindsay, myself, or any other member of our team. We'd be more than happy to talk with you. So have a great day, everyone. We'll see you again in a month or so.
Thanks,
Bye.
Amy.